Good morning. Are you Justice Larzo?
Yes, ma'am.
And Mr. Larzo, in cause number 26 DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part.
What you're charged with?
The part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand? Sure.
What it says is if you convicted, if you catch the case, 2 of the cases at the same time, then that would be consist of the enhancement. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran a CC.
Here's the thing. It only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by 1 instead of turning it into a habitual. So I'm only counting it like it's 1, right? So let's just assume you have 1 prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this 1 level, which means from a third degree to a second degree, just like I said. Make sense? Okay. So
I'm sorry to interrupt,
Sure.
if I may.
Yes.
For the benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
All right. Thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzo yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said 5-year cap. I don't know what that is. That's not an offer. If you offer me 5 years TDC or you offer me 5 years probation, you didn't say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TDC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I received at a sentencing hearing. But if I follow the agreement, I couldn't give you more than 5. So it's something where it's not for sure. You have an opportunity to ask for something within that range. Does
I'm
that?
trying to tell me this today.
What?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right? You can go back with the bailiff. Joey Mink.
Joey, me?
The paperwork on this one. Oh, I don't have it yet. All
Yeah.
Not for your sake.
Good morning. Are you Joey Mink?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
He will, Your Honor.
I'm gonna need,
And Judge, I'm going to give you a heads up on this. The motions were, you're going to shake your head if they don't match up or if they've been administratively difficult, for lack of a better.
let me get them printed out real quick and we can all be.
At one point in time, the probation department only wanted one filed, and then the clerk asked why there wasn't two filed, brought that to my attention. So I filed the second one. So if there's errors, I apologize in advance.
So we'll just start with the first one. There's
Just when you think one case is over, another defendant steps forward with an entirely different problem. This time we're dealing with probation violations, and those often move much faster than regular criminal trials. Once someone admits the violations, the outcome can change in just a few minutes.
Mr. Mink in cause number, and he'll waive the formal reading in both.
He will, Your Honor.
Okay. So, Mr. Mink, in cause number 23 DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of evading arrest or detention with the use of the vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24 DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 6-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you violated the special amendment requiring you to successfully re-enter the safety program. And is that true or not true? True or not true? And then in cause number 24 DCCR 0294, that motion also alleges in count 2 that you failed to provide verification of performing the community services required. Is that true or not true?
True.
And count 3 in that case alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to all of those counts freely and voluntarily? And did you plead true to them because they're actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. And is the punishment the same?
Yeah.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas of true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23 DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24 DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The 2 cases or the 2 sentences will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff.
Okay.
Just that one?
Yes, one. Thank you.
Let's see. Kashonda Riley to sentencing.
In less than 10 minutes, we've watched two very different courtroom situations with the same underlying lesson. Every decision before and after a conviction has lasting consequences. Prior convictions, plea agreements, probation conditions, they all shape what happens long before the final sentence is announced. If you enjoy real courtroom breakdowns where we explain the legal strategy, courtroom psychology, and the biggest turning points, make sure to subscribe because we've got plenty more cases like this coming your way.